court. I'm Hank Shelton of the Memphis Bar, representing Regions Bank and its subsidiary, Regions Affordable Housing. It's the second time we've been before the court on this case, but this time there are no procedural issues and we can proceed directly to what is the key issue, which is the interpretation of the limited partnership agreement between Lexington Charter. Yes, sir.
Would you like any rebuttal time?
Thank you, Your Honor. 5 minutes, please.
5 minutes, all right.
And I think I've been doing this long enough. The question is one of interpretation of the limited partnership agreement. And as I read the briefs and remember the proceedings below, we're not really arguing about the legal principles. I think the standard of review is agreed by the parties. The principles of contract interpretation in Tennessee, I think, are accurately set forth by both parties. So what I want to do today is focus very briefly on the facts and then spend most of my time looking at the contract itself. Let me start with the facts. The facts are that the general partner engaged Mr. Spence's law firm, or a prior law firm, Mr. Spence anyway, and Ms. Wu to file an injunction lawsuit to enjoin a foreclosure of the properties that were owned by Lexington Partners. They did so without seeking permission of Regions. They proceeded to litigate over the course of several years with absolutely no advantage to Lexington Charter. There was a temporary...
Are those the fees we're talking about here?
Yes, sir.
Okay. That's what I'm trying to make sure I understand. I know the first appeal dealt with a certain amount of fees. And the second, when is the time as far as the second?
Yes, sir. I should have set forth the case.
When does that begin and end?
I should have set forth the case better. What happened after the first appeal was Lexington Charter, through Mr. Spence, filed another fee application before the chancellor to secure fees for the cost of the prior litigation, the appeals. The chancellor granted those fees. We argued about it. We were allowed to intervene at that point, disputed the fees were due. He granted them. We appealed it. That's where we are.
Okay.
Let me
So the first fee's off the table?
The first fee is, I think, off the table.
Okay.
I'd very much like for it not to be, but that's where we are. In awarding the fee, the chancellor considered the services performed and the language of the contract and determined that the contract permitted Lexington Charter to engage counsel to litigate the appeal or to litigate generally. We dispute that. The initial litigation for which the Spence Law Firm was hired was ultimately unsuccessful, resulted in the appointment of a receiver by agreement. The receiver sold the property, yielding proceeds, and Regions and the law firm have been fighting over the proceeds ever since. Then let me, if I can, proceed to the contract language itself, which I think matters considerably. We addressed it in our reply brief. Both parties have addressed the contractual language. Let me outline what that contract does. It's a limited partnership agreement. The purpose is to principally provide low-income tax credit housing, and that's it. It is an unusual limited partnership agreement in that although there is a general partner, the general partner's management rights are severely restricted. Now, the way that works is looking at the contract, Article 5.4, or I'm sorry, 5.2 of the contract grants the general partner substantial authority to manage the general partnership or the limited partnership. 5.3, however, contains 22 restrictions on the authority of the general partner. They're denominated A through V. Of those 22 restrictions on the general partnership, roughly 19, let me make sure I've got my numbers right. May it please the court, hold on. There are 12 sections that refer to the term partnership. There are 9 of these little articles that don't mention partnership at all. There is one, subsection V, which uses the term partners. Partners is not defined in the limited partnership agreement. Partnership is, general partner is, limited partner is, and partner is, but partners, plural, is not. That matters. The reason it matters is if you look at subsection 5.3, the restriction subsections, 12 of those restrict the ability of the general partner with regard to the partnership. For instance, the general partner cannot settle any claim against the partnership for more than $15,000 without Region's permission. Subsection V is what brings us here. We submitted to the court below and submit to you that subsection V prohibits the engaging of counsel for anything in excess of $10,000 without the special limited partner, that is, without Region's permission. What the...
And what language do you rely on for that interpretation?
Well, because the paragraph itself says that the general partner may not make any expenditure or incur any liability on behalf of the partners in excess of $10,000, which is not identified in any budget consented to by the special limited partner, except with respect to emergency repairs.
So in this case, did the general partner incur any liability on the part of a partner or partners in excess of $10,000?
Well, he certainly did it on behalf of himself as the general partner. The question is, what does the word partners mean? And let me connect those dots for the court. I think reading that plainly, explicitly, and without thinking, you think partners. But the fact is, the way this agreement works, you're not talking about partners, you're talking about the partnership.
Well, that would be contrary to partnership law, wouldn't it?
No, sir.
Because under partnership law, there's a difference between the partnership and the partners.
There is indeed a difference
And the
between...
reason we have partnership law is so that you can have kind of the same protection that you have with a corporation. Like corporation shareholders are not responsible for the debts and obligations of the corporation. With a partnership, partners is a partnership is a distinct entity from a partner, and partners aren't responsible for the debts and obligations of the partnership, as I understand it under partnership law.
Well, let me answer that two ways, Your Honor. Number one, the general partner is excuse me, the general partner is absolutely liable for all the debts of the partnership. That's what general partners do. That's under both the Limited Partnership Act, the Uniform Limited Partnership Act, and the Uniform Partnership Act. So the general partner is absolutely positively liable. The limited partner is the one whose liability is limited, hence the term limited partner under the ULPA. The question here, though, is when the parties wrote partners, did they mean partners or did they mean partnership? And that is something that the court can determine from the plain language of the contract. It says partners, but let me give the court an example. Make any expenditure on behalf of the partners which is not identified in any budget consented to by the special limited partner. Okay, where does it talk about budget? 9.7. 9.7 says, by March 15, and prior to the, by March 15, the tax return shall, no, I'm backing up. Section 9.7 reports, the general partner shall cause to be prepared and delivered at partnership expense to each partner the following information. B2, an annual operating budget of revenues and expenses for the partnership for the next fiscal year, which shall include a detailed list of revenues and expenses in a form approved by the special limited partner. Again, that's 9.7 B2. And what it says is, for the partnership, the general partner must provide a budget. It's the only place, Article 9 is, where budget is mentioned. It's a defined term. You go back to 5.3, the only point of the budget is for the partnership. There's no such thing as a budget for the partners under this agreement. My time's up.
Thank you, sir. You still got your rebuttal time.
Good afternoon, may it please the court. Robert Spence of the Memphis Shelby County Bar. This appeal arises from the August 24, 2023 trial court order granting Lexington Charter's motion for attorney fees. And I think that particular order is illustrative of the issues that are before the court. The trial court order reflects that in pursuit of the attorney fees, Lexington Charter identified 3 sections of the partnership agreement. 5.2D that allows for the general partner to employ attorneys on such terms as the general partner shall determine. Section 5.2F, which allows the partnership to defend legal action or demands of or against the partnership. And Section 4.5A, which is the distribution of the net cash proceeds from a sale, and there was a sale in this case. And in particular, that particular provision says that the order of payment is the payment of all expenses and debts and liabilities of the partnership. The trial court found that the general partner had the right and ability under the limited partnership agreement to retain counsel to defend against the action brought by Regions, and that in addition, under Section 4.5, that the work performed by the creditor, which is in this case is my law firm, that work was incidental to the sale, because all of this dispute arose as a result of the sale of Lexington Charter Apartments. So the trial court found that under several provisions of limited partnership agreement, the general partner had the right and authority to retain counsel. The trial court also found that the work performed by the creditor, my law firm, was incidental to the sale and was an obligation of the partnership, and that those fees could be paid out of the proceeds from the sale. That's the priority of payments, and that's what is before the court. The appeal filed by Regions argues that the trial court erred when it found that the partnership agreement provided for and allowed the general partner to engage and pay counsel without the limited partner's consent. So that is the issue that is before the court. The trial court also articulated what was the only issue raised by Regions in the trial court, and that's the provision that has already been discussed, 5.3V, And that provision by its plain language has no applicability to debts of the partnership. So I submit to the court that the decision by the trial court was correct and should be affirmed. With respect to the first question that was raised, the legal fees in this case began January 22, 2021, which is after the other issue that we argued a couple of years ago before this court. And so the fees that were incurred from 2017 to 21, to the beginning of 21, which were at issue in that case, are not at issue at all in this case. The fees that were incurred from January 21 through the work in the Supreme Court are the issues, are the legal fees that are at issue. And I believe that the trial court interpreted the agreement correctly.
Is the substance of any of those fees at issue? In other words, did that have anything to do with the sale, or is it just simply the defense of the payment of fees? That's
well,
kind of a broad question.
No, it is. The trial court found that it was. The trial court found that the dispute regarding the sale originated by Regions, that it just continued. It continued through 21 and 22 and 23. That all of that was based upon the sale of the property, and that's the finding that the trial court made in his order that he issued in this case. So the trial court found that it was incident to the sale. The trial court also found that the partnership agreement allowed for the general partner to retain and engage my law firm to defend the action brought by Regions. Thank you.
Thank you, Your Honor. Let me just address the things that Mr. Spence talked about. Let me start with the court's question, Mr. Spence, about expenses of sale. The expenses of sale are set forth in great detail in the record in this cause. The sale came about because the receiver appointed by the court got a sale. There was a motion filed to approve the sale. The motion was filed by Fannie Mae, FNMA, and by the receiver. It was not joined into by Lexington Charter. It was strictly handled by counsel for the other two parties. As far as the record is concerned, the only relationship that Lexington Charter's counsel had to the sale was signing the order approving it, which I think is significant. This is not an expensive sale, can't be related to an expensive sale. It is specifically not the kind of expensive sale which under Tennessee law comes out in a closing statement, for instance. This is litigation that happened long since, so it has nothing to do with the expenses of sale. So we get...
Was that the only basis for the trial court granting the attorney fees?
It is one of two, Your Honor. It was literally in the first appeal and here, one of two.
But when you look at the motion that was filed by the Lexington Charter, they don't simply ask that the attorney fees be paid. They're asking that any of their debts and obligation, which would be attorney fees, be paid. And then they're also asking that they point out that the matter is resolved and they want the case closed. And you file a motion to intervene and the case wasn't closed. Is that right?
I think Tennessee law is funny on that, Your Honor. The case was closed as to the merits. It stayed open for purposes of attorney's fees, as cases do in this state.
And then later, in this case, they also filed a motion, but it doesn't really say, it includes attorney fees, but it says any of their debts and obligation.
Right.
How do you And then the partnership agreement says that if there's a sale of the property, that any debts and obligation of the partnership shall be paid before the disbursements to the partner.
Again,
So if these obligations are not paid, what happens with the obligation owed by the partnership to the Spence Law Firm?
it's paid by the general partner. That's just quite clear under the agreement. The general partner engaged him, the general partner had the authority to engage him for the general partner, but by agreement, the general partner did not have the authority to engage counsel and spend more than $10,000. They could spend $9,999.
Well, I know that's your argument, but on the partnership law, a partner, or adding an S to it, partners, doesn't make it a partnership. And that provision simply says that you can't obligate a partner in excess of $10,000.
No, with respect, Your Honor, it says you cannot obligate. It says partners, it means partnership. That's the whole point of the budget and 5.2.
Well, if they-
This is a, if I may, Your
The
Honor.
lawyers drafting this, if they intended it to mean partnership, why not include it there in that provision?
My own opinion is it's a typo. Somebody left off 3 letters. Because it doesn't make sense. The entire point of 5.3 is to limit the ability of the general partner with regard to the partnership. That's why I went through that long process about 22 separate entries, all of which relate only to the partnership and not at all to partners. There are in the agreement many references to partners, but they have to do with things like partners' accounts and the rights and rules of the general partner, which is what we're talking about here, are the right and obligation of the limited partners. This paragraph, 5.3, talks only about the partnership, except for that one word, partners. And, again, as a matter of partnership law, the general partner is bound by the limited partnership agreement as a matter of contract. The general partner had every right to engage Mr. Spence on the general partner's own dime, but not to use the limited partner's money with respect to it. And as far as paying off debts and obligations, no, it was an obligation the general partner incurred in violation of the partnership agreement, because there's no other reasonable way, no other unreasonable way, in my judgment, to read subsection V of 5.3. It talks about a budget. Budgets don't apply to partners. It talks about authority to represent the partnership, not the partners. It just says on behalf of the partners. Clearly, I think it's a mistake, and it's a mistake.
So are you saying it's ambiguous?
I'm sorry, Your Honor.
Are you saying it's ambiguous?
I don't think it's ambiguous at all. I think it's just a typo.
Well, that sort of sounds like you're saying it's ambiguous to me.
Then it's ambiguous, Your Honor, because it cannot mean anything but something that it doesn't say. It means partnership. It says partners, no doubt about it.
Okay. All right, gentlemen, we
Thank you.
appreciate your argument. We will take this matter under advisement and attempt to get you an opinion at the earliest possible time. That concludes the call of the docket for this session of court. We'll stand in recess to the call of the docket. Ms.
All
Angie.
rise.